Okay. Well, welcome everyone. I really appreciate folks taking the time out of their busy schedules and busy lives, especially on a nice warm summer day, to be able to join us for a little bit here to learn. The Westward 360's education program has been really exciting ever since we launched this back in July of last year, and we've been doing a number of these, typically at least one a month, sometimes even two per month. And I was mentioning at the start, as some folks were trickling in, it's been nice to see some recurring faces and a lot of people who've been taking advantage of this opportunity, especially when we get really tremendous expertise from people like Dawn Moody here, who really is just unparalleled in the law side of things for the HOA industry as a whole, and comes in with a really tremendous breadth of experience. So just a quick introduction. I am Eric Stazak, Westward 360's Executive Vice President. I'm responsible for new business and business development here at the company. Formerly was the department head for all of our association operations for about 8 years. But we've also got Dawn Moody, more importantly, who's on the call with us and who's going to be helping us run through any questions and concerns and just overview of electronic voting, electronic communication, and the rule adoption process. So Dawn, would you mind giving a brief introduction to yourself, and we can go ahead and get started?
I always hate talking about myself. Good evening, everybody. My name is Dawn Moody. I am a principal attorney with the law firm of Keough Moody, which is a law firm based in Naperville and Chicago, where most of our practice is focused on representing condominium, townhome, and homeowners associations with their general day-to-day affairs and anything that pops up association-wide. So, Eric, should we jump into this riveting topic? We're kind of joking at the beginning of this presentation about how I'm not really good at technology, and I'm still trying to figure out this whole Google Meets thing. And that my 8-year-old son is absolutely fabulous at this, and I'm lucky that he didn't change my avatar or my camera into a cat or something for the presentation. I said, well, maybe that would be fun, because this is not the most engaging, most exciting topic there is out there for community associations. However, it is a good topic because it is going to help boards and associations run a little bit more efficiently. So tonight, we're talking about the fun and exciting topics: electronic voting, electronic communication, and how to adopt the rules that are associated with that. So, Carrie, if you want to move to the next slide. So, e-communication. So, several years ago, the Illinois legislature decided to update the terms, the Illinois Condominium Property Act, which applies to all condominiums in the state of Illinois, as well as the Common Interest Community Association Act, to basically bring the document up to date with some current technology. And instead of providing that for delivery of notices, so official notices like your election documents, your budget documents, meeting notices and whatnot, that instead of it just going out by mail or hand delivery, that we're going to include an option for boards to be able to send out this notification through acceptable technological means. The definition, and it's the same in both the Common Interest Community Association Act and the Condo Act, is it includes without limitation. So it's very broad, and it's meant to encompass subsequent technology that comes into play: electronic transmission over the internet or other network, whether by direct connection, intranets, telecopier, electronic mail, and any generally available technology that, keywords here, by rule of the association, is deemed to provide reasonable security, reliability, identification, and verifiability. So it's the catch-all. You can send out notifications electronically. The way that most associations are doing it is by email notification. It could theoretically include text notifications. Eric, I don't know if Westward 360 is doing anything different besides email and text. I think those are the two that I hear most commonly come up when I'm talking with management companies.
Yep, that's right. And that's how we operate as well.
So we now have different ways to send out official notices to our members, but there's some caveats to it. So we can use acceptable technological means. So we can do it through any notice, vote, signature. We can do it all through the use of technology. But in order for us to use it, owners need to opt in and affirmatively consent. So Couple steps here, kind of taking a step back. The definition is by rule of the association. So the association, in order to use acceptable technological means, they need to adopt a rule outlining what that is. Is it electronic mail? Is it text messages? Is it something else? It needs to be specified in the rules and regulations of the association, properly adopted by the board, which we will get to in a second. And then in order for the association to pivot to sending me notice from like by mail to sending it to me via email, I have to affirmatively agree to receive electronic communication instead of getting my snail mail association notices. If I don't like email, and to be honest, I don't like email, the association then has to continue to send me notification out by regular mail at no additional charge to me. So for associations looking to do this, a lot of boards want to do it to everybody out of the gate. We're just going to shift. We're going to save ourselves some money in the budget. We're going to pivot from doing from doing regular mail to electronic mail. But we can't do that without people opting in. We can't force it upon people. We can just highly encourage people to agree to receive email notifications instead of getting the hard copy mailings. For the associations that do it, and Eric, again, I'm going to kind of look to you for a moment. But what ends up happening is if you have half the community that is opted in to receive email communications, your management company is sending out the notices via email to that half of the community. And then you're doing snail mail to the other half of the community. And unfortunately, that is going to be done, as part of the common expenses of the association.
That's right. And then typically just on our end within the management software, and we use Vantica, we have that ability to view who has opted for, like on a more of a self-service basis, who's put in that electronic communication is something that they're interested in or okay with. They have the ability to differentiate between whether or not they want like their billing statements for their assessments to come in via email, but then want all other correspondence via regular mail. The nice thing about that too is that because we kind of have some of that opt-in, opt-out visibility, we make sure that we're not sending, duplicative notices to the folks that have properly opted in and submitted those forms that that Dawn has talked about as well and referred to. And then one thing we will be doing is starting to create a toggle above the opt-in within Vantica, so that makes it at least the streamline and process of opting in for that a little bit less mechanical, less manual, that you have to do that, and it might make it easier to get folks to opt in for that rather than some of the laborsome things that Dawn might be getting to in a little bit here. So
I will. Carrie, can you move the slide, please? So just kind of some practice pointers. We have the technology, we have the legal ability to pivot to utilizing electronic communication. At this point in time, we're somewhat in an area where you can't teach an old dog new tricks. So I think it's going to be something that's really going to take some associations some time to kind of pivot to, and the same thing with owners. I think if you have a younger crowd within your association, you're going to see a lot more people opting in if given the opportunity to electronic communication. Whereas some of the older generation, I'm going to include myself in that mix, I like to receive hard copy mail. I want to hold the paper in my hand, and I want to receive that. So kind of some tidbits here. Boards, if you're going to look to allow electronic communication in your association, regardless of whether you're a condo association or a non-condo association, you need to adopt rules specifically allowing for it. We have to have a process. And again, Eric and Westward 360 is happy to assist in establishing the process for opt-in. You want to make the process, as Eric has suggested, as easy as possible. When you're having people fill out forms and send those forms back in, if they have to put something in the mail, put a stamp on it and put it in the mailbox to get back to the association, 9 times out of 10, they don't do it. So if we can do it electronically through a portal where they can where your owners can go in, log in, put in their email address, that's going to make things easier on your owners and easier on you as the board. So we can only send those electronic communications to those people who agree to that. And for everybody who doesn't, they're going to continue to receive the regular notifications. Again, your e-communications, this whole thing relates to your official communications of your association. Boards send out a lot of stuff to their residents that is not official communication. Newsletters is not generally going to be official communication. A heads up notice about we're going to be doing work or this is going to be happening. Those are not official communications. Your official communications that have to go out by regular mail right now or hand delivery, depending on the governing documents without this resolution in place, includes your annual meeting mailing, your budget mailing, any rules and regulations that you're looking to adopt, any amendments to the declaration, and then board meeting notices to an extent, in addition to posting notification on the property. So if this is something that your association is looking to do, again, separate rules and regulations need to be put in place to allow for it. And then you need to make sure the rest of your rules and regulations are updated to say, if you've opted in to receive electronic notice, you're going to get that violation notice electronically versus by certified mail. So that's kind of, again, e-communication in a nutshell. It's again, not really riveting. It's out there as an option. It's an option more boards are starting to do as a way to try to increase the margins in their budget and shrink, the postage and delivery and reproduction costs. So the next electronic thing that we're talking about, and again, it always cracks me up that when it's me, the attorney, talking about electronic things, because attorneys are not known for their great use of technology. Electronic voting, e-voting for condominium associations. So if you have a condominium association and you do your annual election, the default rules, meaning in the absence of the board having, the association having different rules to the contrary, default voting procedures for condominium elections are you can come to the board meeting in person and cast your ballot, or you can attend the meeting by proxy. So what that means is if I'm not going to attend my condominium association meeting, I can give my proxy to Eric, and Eric is going to attend the meeting and he's going to cast my vote for me. Most proxies are directed proxies these days. So the proxy will say, I, Dawn Moody, give Eric the right to act as my proxy at the annual election on XYZ date, and I direct him to vote for the following candidates. That proxy is not a direct ballot. And by that, I mean, if Eric decides he's got better things to do on a Wednesday night, as opposed to go to the board meeting, Eric isn't there to cast my vote and there's not a backup proxy holder on that document, my vote doesn't get counted. So it's somebody has to act on my behalf. Part of the reason that I don't like proxies, because it puts a middleman in place that I don't think necessarily has to be there. So the Illinois Condominium Property Act lets boards adopt rules to do their elections in different ways. So what we're talking about tonight is electronic voting. In addition to that, the Illinois Condominium Property Act says throw those proxies out the window. You can adopt rules that say we're going to do it by ballot. So somebody can appear in person and cast their ballot, or they can send in a mail-in ballot. So it's kind of, similar to the proxy where you're crossing off your votes and saying, here's who I want to vote for, but somebody doesn't have to be there to cast your vote on their behalf. Regardless of what's in your governing documents, the Illinois Condominium Property Act says the board by rule can adopt this process, although there is a procedure that the owners can pull it back. This procedure has to be adopted at least 120 days before the next annual election in order to take effect. In addition to ballots, we now allow for electronic voting. So condo associations, you can do ballot proxy, that's your default. You can do ballot in person, ballot by mail, that's your second option. Or the third option here is going to be I can attend the meeting in person and I can cast my vote, or I can submit my vote electronically. And that can be done in a variety of ways. There, you can send it in electronically. There are electronic voting companies. Eric, do you want to touch in on the specifics of how electronic voting works at Westward 360?
Yeah, so in many cases, we have opted to recommend to board members, or maybe boards have been interested in getting one of those e-balloting and voting kind of third-party companies involved to help run that election. We have also started to develop electronic balloting of our own that we've been able to help develop through things like Google Forms and other sort of similar sort of balloting measures, so that if any of you have ever received like a Google Form version for like a survey or anything like that, where you're opting for your selections about, maybe the board prompts for, hey, we're looking at, refreshing the lobby area, and we're looking to get some people's weigh in on their preferred color or style selections. Very similar kind of, mechanic where you're just going through, you'd have the candidates listed there. You're checking off that you affirm that it's truthfully you submitting and completing that ballot. And then we have that level of verification to make sure that the email address for who's submitting it matches the one on file with that owner as well. So depending on what the board's preferences are, whether they would like a third party involved or if they would like us to work with some of our internal tools, we have that option and flexibility.
So again, these rules specifically relate to board elections, your annual election. If you adopt rules providing for electronic voting, people can vote again in person at the meeting, or they can vote electronically. Proxies are out the window. You're no longer utilizing proxies. Your options are either a ballot or voting online. There is a timing requirement set forth in the Illinois Condominium Property Act where you need to send out instructions for voting 10 to 30 days before the annual election meeting, which is common for what you have right now. Your election mailing needs to go out not less than 10, not more than 30 days before the date of the election. You have to give your owners 21 days to declare themselves a candidate for the board. The deadline, there's a timing window there where the deadline should not be more than 7 days before the instructions are being sent out. You have to allow for write-in candidates. So anything that you are providing in terms of electronic voting, there needs to be a spot there where somebody can type in Carrie Surratt as somebody that you want to elect to the board. In the event that you make a mistake, because sometimes you make a mistake, you get an email late at night and you're like, I want to vote for Eric, I want to vote for Carrie, and you change your mind. The procedure has to allow somebody to show up to the meeting itself and be able to change their vote. So voiding the electronic vote and then submitting a paper ballot instead. So owners can challenge the adoption of these rules. This is, again, keep in mind, this part of this is only for condominium associations. The next slide is going to touch on non-condo associations. But this is one of those things that your owners can pull back. So the board adopts these rules to say, we're going to move to electronic voting. They have the ability to serve a petition on the board signed by 20% of the membership within 30 days of adoption saying, we want the community as a whole to consider this. If that happens, we have to call a special meeting. And unless a majority of the total votes of the association are cast to reject electronic voting, it's deemed to be ratified. So this specifically is going to relate to your electronic voting for your annual meetings. You have the ability to also do voting, again, kind of going back to conducting business through acceptable technological means. You have the ability to do anything that you can do in person and by ballot electronically. So you can vote on an amendment electronically. You can send out notification to say, here's what we're going to do. And you can have that vote through, Google Forms or something. We just have to be able to ensure that it's reliable, it's verifiable, and that we can hold on to it as long as we have to hold on to it with the association's books and records. So anything that the membership can vote on, the membership can vote on with the appropriate procedures in place electronically. It doesn't work for the board though. You're not able to conduct board business by proxy, and you're not able to do electronic voting for board particular issues. So Carrie, can we move to the next one? Common interest community associations. If you haven't noticed before, you will now. The rules between condos and non-condos sometimes are similar and sometimes they are not. Sometimes the Condo Act has better rules. Sometimes the Common Interest Community Association Act has better rules. Here, for Common Interest Community Associations, the default voting rules under the Common Interest Community Association Act are: you can vote in person at the annual meeting, you can vote by proxy, or you can vote by association issued ballot. So you have those three options that you don't have when you're a condo, because for when you're a condo, you have to select which one that you're going to do by rule adopted at least 120 days in advance. If you're a non-condo association governed by the terms of the Common Interest Community Association Act, which generally means budgeted assessments of at least $100,000, you can pick either option, or you can again pivot to e-voting. For e-voting, again, you're going to need to adopt rules and regulations. Unlike the Condo Act, where you have to have those rules and regulations adopted 120 days in advance, here you just normally need to follow whatever rule adoption process that particular association has. We'll get into that a little bit later about the difference between condos and non-condos. But for non-condo associations, you adopt them by rule, you follow whatever procedure is set forth in your governing documents. And then if adopted, you cannot use proxies. If you have electronic voting, instructions need to be distributed the same way, 10 to 30 days in advance. You have to allow for write-in candidates, and you have to give the owner the opportunity to request a new ballot in person at the election meeting. From a practical standpoint, and I'll pull in Eric here, my experience has been when associations pivot to electronic voting, they end up getting a better response from their membership. It is easier for them to vote. To an extent, it is idiot proof. And I say that lightly because I've done a number of elections over the years where people either cannot fill out their ballot or their proxy correctly, and it ends up being voided. So when you utilize electronic voting, you can't, if your association doesn't have cumulative voting, and cumulative voting is if you have 3 people up for election, you could check 3 candidates, or you could give 1 candidate all 3 votes. But if you have an association that has non-cumulative voting and you try to accumulate your votes, you're normally going to get kicked out of the system to say you can't do that. So electronic voting makes it easier for people to vote because they just have to clicky and submit their vote. And it stops them from making a mistake with their ballot where it would otherwise be invalidated if it was in paper form. So most associations that I have that have pivoted to electronic voting, they're able to get quorum because enough people will go online and submit their vote because it's minimal effort and it is done correctly. So I personally live in an association. It is a fairly large association. I think we're 700, 800 homes. And we did not have an annual election because we never met quorum for about 15 years. The board pivoted to electronic voting, and we've hit quorum the last 3 years because our owners are able to go online and submit their candidates and send in a ballot. Nobody could do that via hard copy previously because it was just too much effort. Didn't matter if they did self-addressed stamped envelopes. It did not matter if it took effort and somebody walking to a mailbox system to return their ballot or actually going to the meeting, we'd get 20 people to show up. So e-voting is something that I encourage associations to look at, especially if you have a technologically savvy community. It's made a big difference for a lot of our associations in getting participation. Eric, do you have anything to add on that from your side?
Yeah, I mean, I'll second it wholeheartedly. I think the more and more that communities can reduce the barriers of entry to be able to, functionally participate in board meetings. So I know that I know everyone kind of hit like their peak exhaustion with like virtual meetings, for instance, where I know that it was a really nice thing to have for whether it's things like this, whether it's board meetings and things of that nature. But the nice thing about them, even if people got a little bit tired of, Zoom and Google Meet culture and things like that, was that I'm sure a lot of you recognize that more people attended. You got more participation. It became a bit easier to participate if you were someone that, maybe you worked evenings or you had third shift or whatever, second shift, whatever the case might be, and it misaligned with the board meeting schedule. Having something easier where even if you could listen in was, a godsend for some of those folks that never had an opportunity to participate or even know what's going on. Similarly for voting, I think you get a lot of people who, A, I can't attend the meeting. B, I don't know how the proxy, process works. I get confused at Dawn's point about how to properly complete and fill that out. Or maybe I'm confident that I filled it out correctly. And then to Dawn's point, I didn't realize that, cumulative or non-cumulative, what that exactly meant. So you end up having a lot of opportunity for failure, or for that vote to not get cast, or people to just feel kind of disenfranchised and not part of the process. So we've seen the ability to enact these sort of rules where associations that have done that makes that participation that much heavier. I think one of the nice things too, like for those communities where quorum's always a struggle, and just getting people to participate and just even cast like a quorum only proxy in some way, shape, or form was always really hard. You get board members who are running down the hallways, knocking on doors, trying to get people to submit things and hand over pieces of paper. Whereas we actually had a community that did a June annual meeting at the start of the month, and they were one person short of proxy. Short of quorum. What was nice is because they had electronic voting enabled, we were able to send a quick broadcast message as a reminder about an hour before the meeting, and that eked out, 5 more people that submitted their vote in time for us to be able to not only hold the meeting, but now we actually had more ballots and more participation in the election. So the nimbility of it all is really nice, and encourages a lot better participation and more accurate participation as well.
Eric, kind of going back to your point there about that last minute, we need to get quorum. The nice thing about the electronic voting and the electronic voting companies is they're, I don't want to say annoying, but they're kind of persistent in making sure that they're reaching out to you, say, hey, just a reminder, this election's coming up. Here's another reminder, this election's coming up. Here's another reminder, you need to vote. We haven't received your vote yet. And it's easier to do that way versus, via snail mail. You send out your notice 10 to 30 days in advance, and you just kind of walk into the meeting, and either you have the votes or you don't have the votes to move forward. So utilizing the electronic process does, put more reminders out there. Now, if you have a board that's like, we never want to have quorum because we never actually want to have an election, probably don't want to go this route. But for those that are trying to encourage participation in their community, this is a really good way to try to get that participation. And again, for both condos and non-condos, it's going to throw out those proxies, which I think are just a giant pain, trying to find the person that's going to be present at the meeting to then vote on your behalf. So Carrie, move me to the next page. Carrie is doing great running behind the scenes and handling the chat and moving things along. So unlike e-communication, where you have to receive an opt-in from the owner to send them notification via emails, e-voting, people don't have to opt into it. If the board says we're going to do e-voting, adopts the appropriate rules, owners' options to vote are then electronic voting and coming to the meeting in person to cast the vote. The notifications then that go out, they will go out electronically to anybody that has their email address on file with the association. And it will also come via snail mail with a specialized code for people to log in and cast their vote. So rules are going to be required for both condos and non-condos in order to do e-voting. I certainly, again, recommend the use of an electronic voting company, a third party kind of arm's length transaction of having somebody handle that process. Or utilizing kind of the in-house management team. It's not going to be, correct me if I'm wrong, Eric, if you do electronic voting through Westward 360, the community association manager isn't running that. It's going to be the election team handling that. So there is that arm's length there as well.
That's right. And then we're able to usually just rope in someone else who's kind of just non like conflict of interest or anything like that, whether it's an assistant or an additional staff member that can help keep everything honest, track that. And that way the manager stays engaged in the meeting as well and isn't, busy taking a 15-minute break, tabulating votes and things of that nature. So it's really helpful on that end.
So you have to have the ability to void the votes if somebody appears and wants to cast a new ballot. There's kind of some hoops that have to be jumped through if you have an association that has a secret balloting procedure. But that's normally was set up with the electronic voting company or with management. And you have to be able to maintain these records for at least 12 months because it is a record that is available for inspection. So if an owner's like, I want to see the ballots, I want to see the documentation, it's stuff that we do have to make available for inspection. I believe one of the questions that I saw earlier was, okay, so how does this work? in terms of practically speaking. How do we cast the votes, or how do we count the votes between the people that vote online versus the people that show up? And the easy way to say that is your management team is going to get a spreadsheet showing who has voted, and it's going to provide tabulations for the electronic votes. Those electronic votes are going to stop before the meeting. So people are not necessarily going to be able to continue to vote up until, 7 o'clock, 7:30 the night of the election online from home. There's going to be a drop dead date for the electronic voting. They're going to generate a report. Here's who voted. Here are the tabulations from there. Management is then going to be taking those tabulations, again, assuming nobody shows up, and we have to do some math on that end, saying, okay, we're going to avoid Dawn's vote because she decided she doesn't want to vote for Eric anymore. Pull out her vote here, and then we're going to manually count it over here. But you're going to combine those two calculations, the manual votes and the electronic votes, to come up with the end result. So that, Eric, am I missing anything fun and exciting about the e-voting?
No, you got it. And we, just for reference too, we do have a really nice vote tabulation sheet that we use to track those things, that really it inputs those votes, the electronic ones, in real time up until that time that Dawn mentioned, where those votes stop being accessible for casting. And then we have a column too that we track all of like the actual, whether it's the in-person votes or anyone that's actually attending and casting their vote then, so we can differentiate, to Dawn's point, who submitted via which means, if we ever have to do kind of an election audit, or if an owner that likes challenging a lot of things wants to see a record of how people casted all of their votes, we have that nice paper trail there as well. One of the things that Dawn mentioned earlier as well was like that repository of, keeping records of those votes as well. What's nice when people do submit those on our end, when they submit the electronic vote, it actually creates like a digital PDF of that vote as well. So we save that on the association's record, so that in the future, let's say we change management softwares, or we change the voting module that we're working with, we still do have another rung of sort of backup to track that vote. Maybe there's, someone calls into question an election that happened 3 years ago, and now I want to see the votes and all of the data behind that. We have that all saved and backed up and have copies of those. So we're not putting you in a tight position where suddenly, because we did electronic voting, there's a risk of, hey, was the record of those votes kept? Was all of that easily accessible if someone did like an open records request or something like that? So we do make sure that we have all of that repository saved over time, so it's always available and in accordance with the record standards in the state of Illinois.
One of the things that I will say, because this presentation is more focused on the association side of things, the association running the election, the association, voting on an amendment, and the board pushing out that information to the membership. We're also seeing people utilize platforms like change.org to push petitions in front of the board. So I had mentioned earlier, with a condo association having the ability to challenge the adoption of rules, pivoting either to mail-in ballots or electronic voting, there's other issues that the board makes decisions on, special assessments by way of example, the budget if it goes above a certain amount, where owners also have the ability to challenge the action of the board. We've started to see members pivoting to those electronic platforms to get the necessary number of signatures so that they can push it to a special meeting, where we then have hoops to jump through to validate, to make sure that the person that is signing the petition, this electronic petition, is Dawn Moody, and it's not Carrie Surratt pretending to be Dawn Moody. So we are seeing technology, be utilized by both owners and boards kind of going forward to make people's lives a little bit easier to get the information that you need, either votes for an election or signatures for a special meeting put together, so that we can move forward with whatever that next step is, being a special meeting to challenge a special assessment, or to actually hold an annual meeting that we haven't held in the past 10 years because we can never get quorum doing it the old-fashioned way. So we talked a lot about rules and regulations. To do some of these things, you have to adopt rules and regulations. I could keep you here all night talking about rules and regulations, and that is a much sexier topic than talking about electronic communication and electronic voting. So we're going to kind of generally touch on some things. I'm not going to go into the nitty gritty because I know everybody has places to be tonight. And again, I'm not joking when I say I could keep you hostage for hours talking about rules and regulations and how they should be adopted and what should be included. Adoption of rules and regulations. The easy thing that I'm going to tell you right now is if you are a non-condo association, non-condo associations with adopting rules and regulations is essentially the wild, wild west. There are no rules unless the rules are specifically found in your governing documents. So the Common Interest Community Association Act does not specify a procedure. Some association declarations do specify a procedure about how rules and regulations are adopted in a non-condo association. My personal experience has been more times than not, it's just the board adopts rules and regulations. You don't have to follow any sort of process. It's just the board adopts them in an open meeting. My recommendation is for any association, you follow the process that's set forth in the Illinois Condominium Property Act. Why do I recommend this, even though it's not set forth in an association's governing documents? Because nobody can argue it. If you follow the process that the Illinois State Legislature says should be followed for condo associations, even though there's no process set forth in your non-condo declaration, they're not going to be able to make a valid argument that the adoption process, was rushed through and wasn't well thought out. We followed the process that you set forth, the state set forth for condo associations. They're very similar to townhome and common interest community associations. People had the information in advance. They had the opportunity to talk about their feelings about the rules and regulations, and then the board adopted it. So for non-condos and condos, I think you should listen to the process for adoption for condos and follow it just as essentially just a good practice to follow. So adoption of rules and regulations, they're set forth in section 18.4H of the Illinois Condominium Property Act. If you are a condo association and have a procedure that differs from this, my position would be that procedure is likely invalid because it conflicts with the Condo Act. So to adopt rules and regulations, the board needs to send out the entire text of the proposed rules to the membership 10 to 30 days in advance of the meeting. So kind of going back to the beginning part of this, if you're sending out rules and regulations like this, it's much nicer to send that out via email as opposed to paying the costs to reproduce and put that in an envelope and put postage on to get to people's houses. So 10 to 30 days in advance, the board is going to have a meeting on XYZ date and time. The purpose of the meeting is to discuss the enclosed rules and regulations. The beginning part of this, it's technically an owner meeting, which is again why you have that 10 to 30 day notice. It's an owner meeting for the purpose of discussing the rules and regulations. Unlike normal owner meetings, you don't have to have quorum. So you don't need 20% of the owners to show up or 10% of the owners to show up for you to do something. You do need to allow a time frame, and the time frame is within the board's discretion. If you're going to allow 15 minutes, half an hour, 3 hours, whatever the board decides, to let owners bring their concerns about the proposed rules and regulations to the board's attention. Sometimes people have some really good feedback and bring up some issues that the board management, the attorney might not have thought of. And we might want to go back and make some changes to it. Other times people are mad that they live in a condo and they don't like rules. And they just want you to know, I don't like these rules and I don't think you should tell me what to do. At the end of the comment period, whatever time frame that is, the board says, are we going to go back to the drawing board? Which some associations will do, especially if all of your owners show up and they have pitchforks. Or other boards will just simply say, we're going to move forward with adopting it. At the end of the day, again, the board decides whether to adopt the rules and regulations. Some practice pointers here for adopting rules and regulations. Carrie, can you move the slide, please? I am a big proponent of having legal counsel review your rules and regulations, especially if you're doing an entire set of rules and regulations and not just changing a rule prior to mailing them out. Why? We're there to catch a couple of things. Your rules have to be consistent with the terms of the association's governing documents. So if your governing documents, if your declaration says you can have 3 dogs, your rules and regulations cannot then say you get 1 dog, because your declaration is going to prevail over your rules and regulations. We often review the rules and regulations and things that we come up with, and when we review them, is that I have boards that will come up with some completely unreasonable things. So they will, they will say, we want to, we would like you to give us your firstborn child. I'm being dramatic, but something like that where it's not going to fly. I know that it's not going to fly. But there's other circumstances where the board isn't really thinking the issue through. You're thinking in your mind, we can't do a fine more than $25 because we can't go higher. That's unreasonable. Missing the point that the purpose of fines is to get compliance. So if your fine is going to be less than the person coming into compliance, they're not going to come into compliance. I just saw a post today on X, and it was talking about a swimming pool, and it was like the cost to install an in-ground swimming pool, $12,000. The cost to install this pop-up swimming pool, $800 to Costco for this pool, and $25 a week fine. Like, it's more cost effective for me to put up this pool that's completely in violation of the association's rules and regulations, rather than put a pool in place that complies with the rules. For single family home associations, recreational vehicles, boats, those sorts of things, where they will say, okay, well, here's what our fine is. It's going to be $25 a week. It is more cost effective for them to keep the boat in the driveway and pay the $25 a week fine than it is for them to go store the boat somewhere else. Make sure your fines are high enough that they're going to compel compliance. Leasing violations, same thing. If you're charging a very low fine, it's not high enough. You want to deter the conduct. That's one of the things that lawyers can tell you is your fines aren't high enough here. You need to have a different procedure, because if you want to stop this conduct, this is the tool that you have. The other thing with rules and regulations that we see too often is they read like an etiquette book. And I say that in terms of, owners should be mindful of their neighbors. Owners should be sure to shut the security door. They're more of things that you should do versus things you must do. Your rules and regulations should read like you are talking to my 8-year-old son. This is what you have to do. I know it is not nice, but if you want enforceable rules, they have to be clear, and they have to be rules, not suggestions. Rules that work for some associations, because I know, Eric, I'm sure that you get this, and Carrie does too. Like, oh, well, just give me some sample rules and regulations from other communities. What works in one community isn't going to work in another. And that's something to be mindful. So having your attorney review the rules and regulations, they're going to be able to, again, ensure that it's consistent with your governing documents, ensure that it's consistent with the law, because the law is always changing, ensure that your penalties are going to be enforceable and address the conduct, and make sure that what you have there is something that you can do something with, as opposed to something that we're going, I can't really do anything about this because your rule is a suggestion and not a rule. Plan to review your rules and regulations every 3 to 5 years. Things change. The things that we are dealing with since COVID, I can't even explain the conduct that owners are engaging in their condominium buildings in particular. You wouldn't think that you'd have to tell somebody things like, no, the dog run area is not there for you to have your children play. Can't tell somebody, you can't fine them for doing that, because the rules don't say the dog run area is only for dogs, not for children. Harassment policies, stuff like that, making sure that you have rules in place that meet today's problems. And sometimes you have things in your rules and regulations that made sense 20 years ago that just no longer make sense because they're things that the developer cared about and you don't. So yeah, laws change, new problems arise, and things change. Something that made sense 10 years ago, it doesn't make sense anymore. And people are doing some wild and crazy things that you just, every day is a new day in our office. There's new things that people do, and you're going, I can't believe that this, I can't believe that this just happened. let's make sure kind of going forward, we make some adjustments to our rules and regulations so we address this problem when it pops up at this community, because at some point it will. And that essentially is all I have about the fun and exciting topic of electronic communication, voting, and rules and regulation kind of adoption process. So if we want to pivot to some of the questions, Eric, or
yeah, absolutely.
Or we can tell more stories about.
So I can go through a couple that popped up in, well, I have one that popped in the chat. So Chris had asked, what if we are voting on adopting a new rule to our rules and regulations and looking at to vote on things outside of an annual meeting and a board election? So Chris, you might need to pop on to just clarify that if Dawn didn't answer it.
Hey, so thank you, Dawn. This has been phenomenal. I have 3 pages of notes. So if any night you want to sit up talking, I'll sit with you. Okay. I learned a lot. But so we already have an existing rules and regulation document that is probably as old as some of those ones that you were referencing. We're wanting to add a new rule to it about feeding wildlife from our units in on the grounds, whatever. Do we just need to send the language out, have an owner meeting, and then the board acts? We don't need the vote of everybody?
Correct.
Oh, that makes things a
We
lot.
send out the language 10 to 30 days in advance. You'd give owners the opportunity to comment on that. And then the board would adopt the rules and regulations, the updated language.
Perfect. That's very helpful. Thank you.
It's easy.
And that is just to reiterate, like that is a very common question and misconception we get a lot from boards, where they're afraid of some of those rule updates because they conflate it with the process for adopting amendments to their declaration or bylaws, which obviously is a much more onerous process. And then they don't realize that some of these things that they're trying to enact, obviously, per Dawn's point, making sure it aligns with your declaration and it's enforceable. But the process, whether electronic or even just more analog, is much, much simpler and is much more in the board's hands than they otherwise think sometimes.
I will tell you the big thing, if you are doing a leasing restriction. So if your association says we're going to put a leasing cap of 20% in our community, that is one of those things where your red flag should go up, because leasing rules are generally going to be something, depending on what you're doing, may require a declaration amendment versus a rule.
Right.
So there is case law out there. I mean, we try to make every argument that we can, but there's case law out there that says if you have a declaration that implies that everybody has the ability to lease, which a lot of them do, you can't then put a restriction. You cannot cap leasing at 20%. You can't put a seasoning clause where somebody has to own for a year then to be able to lease. You can't do that by rule and regulation. You're going to have to do a declaration amendment. And one of the things that I will say about declaration amendments versus rules, there's different levels of scrutiny. So if you have a provision in your declaration that says you can't lease, a judge is going to enforce that, because it is not unconstitutional in violation of public policy, and it's not arbitrary in its scope or application, which are the only 3 reasons that a judge can override a restriction in your declaration. When it's in your rules and regulations, and in your rules and regulations alone, it's in the eye of the beholder, which is the judge gets to decide, do I think this rule is reasonable? And that's one of the things your attorneys can tell you, because what can be reasonable in DuPage County is not reasonable in Cook County. It's not reasonable in Will County. And, some judges are just, we have to be sure that what we're doing is reasonable in its scope and application, and it's meant to foster community living and property maintenance. And we're not imposing ridiculous restrictions, which, sometimes we got a problem we want to deal with, and we think we should do it by putting in rules and regulations. And instead of doing that, we just need to kind of attack the problem child front on.
Paul, you had a question?
Oh, yes, thank you. Dawn, I have a question. In general, can board members discuss online email? We were told by our lawyer that we cannot discuss anything by email, that I guess you risk not including another board member, but then that everybody's on the email CC list, right? But
Yeah.
what is,
Well, so the first thing I'm going to say to you is the phrase dance like everybody, dance like everybody is dance like no one is watching. Write an email like one day it'll be read aloud at your deposition. That's the first thing that I'm going to tell you. Anything that you put in writing in an email can and will be used against you at a later point. So be very judicious about what you put in email to begin with. So that's step one. Step two is there is case law, the Palm versus 2800 Lakeshore Drive case that implies that if you have an email chain with all of the board members on it discussing association business, that is considered to be a meeting. And if you're having that discussion, the question becomes, is it a meeting? Is it a meeting where you're lawfully entitled to discuss the particular issue because you're doing it? It's an executive session topic. You're talking about your landscaping contract. You're talking about somebody's unpaid share of assessments. It's one of those specific executive session topics that you could theoretically get away with. But attorneys all kind of take the position, we don't necessarily want board members emailing about association matters because, again, it can be viewed as a meeting. It can come back and bite you because there are board members that will put things in writing that they shouldn't put, and it's often not productive. You have a very congenial board in place, and they can have a discussion about association matters, and it's all well and good. I have board members that will get an email from the community association manager about a certain topic. I will go to bed and I will wake up with 60 emails in my inbox where the board members are essentially screaming and arguing back and forth via email. When email should be used to disseminate information, it shouldn't be used to have a discussion. It shouldn't be a substitute for a meeting. Even if that meeting is an executive session, it should just, here's the information, review the information. If Carrie needs to know something, let her know. But if it's what about this, what about that, questions back and forth, you really should not be relying on email because it is illegal to an extent. You should be having a meeting. The next thing I'm going to say to you with that, there is no such thing as the condo police. So if you are doing things that are technically in violation of the Illinois Condominium Property Act, like conducting business via email when perhaps you shouldn't be doing it, the condo police are not coming to your door and arresting you. So the liability comes if you have that one owner who's upset with the board and decides to file a lawsuit to say, you're not conducting business in the sunshine, I'm suing you for breach of fiduciary duty. And that's the way that they're kind of pushing you and penalizing you for not strictly complying by the book with how the state wants you to conduct business. I mean, that's what happened with Palm versus 2800 Lakeshore. Gary Palm was unhappy about how his board was conducting business. They were doing it behind closed doors. They would come to a meeting and essentially rubber stamp everything, and everything was being taken care of via email, via secret meetings and everything else. And that's, why we have this case that came back out to say, if you are making decisions, if you are discussing association business, you really need to be doing it in front of your membership unless it's one of these specific items.
Mm-hmm. Okay, thank you. Thank you.
Right. Perry, you had a question? You're muted.
Sarah just wanted to say hi.
I'll give her a minute to get unmuted. So we had a question from the forms that were submitted when they RSVP'd. So we have residents who are tech challenged. Some don't even own a computer, and the meetings are held via Zoom. Owners can use their phone to call in, but don't even bother. What options do the board have?
The purpose of a board meeting is for the board to conduct business. So the first thing, that's what I have to say. The purpose of a board meeting is for the board to conduct business. It's supposed to be open to the membership if they want to attend. But board meetings and how they are conducted, if they're virtual, if they're in person, if they're at 7 o'clock in the evening, if they're at 2:30 in the afternoon, whatever the case may be, it is what works for the board to conduct business so that you can gather together in a setting that is open to your membership for them to witness democracy in action. But again, at the end of the day, getting your 5 board members, 7 board members together to do the things that they need to do in a forum that works for them. So I say that because that has to be the focus. For your membership meetings, those are the meetings where you do want your members to be present. And that is when you probably should be pivoting to, is there a different platform that's going to work for the membership? Is an in-person meeting going to work better for the annual versus a virtual meeting? Do you need to rent a room at the library or at the restaurant down the street to have that meeting to encourage people to attend? My personal opinion with this and my experience has been the people who are going to attend your board meetings are going to attend your board meetings. The people who are not currently attending your board meetings are unlikely to attend the board meetings, even if you change how you're handling them. So you can certainly send out a survey, say if that's what the board wants to do. Would you attend board meetings if they were at different times, at different locations and different venues? But my suspicion would be you're not necessarily going to get a response. And I'm more concerned about what works for my board members than I am about whether 30 owners can attend. Because if the distinction is between a quorum of the board or 30 members, I need that quorum of the board because that is what is needed to conduct business.
Thank you. Carrie, are you?
Hi, I got it finally working. So nice to meet you, Carrie. I obviously I know Eric knows who I am, and Eric, this goes out to you. I just want you to give your pooch a big hug for me because I miss your dog.
Will do, Carrie.
And I hope you're doing well. And Dawn, thank you, and Eric, thank you, and Carrie, everybody from Westford for putting this together. I'm going to try to keep this in the shortened version, but I live in an association also in New Lenox. I'm the board president, have been for the last 4 years. Our governing docs are quite antiquated, and I bring this up because when they were put into force, satellite dishes, DirecTV, all that did not exist. We just had a little disclosure paragraph in their like welcome packet that said, because as you said, times change, that if you're going to put up a satellite dish, it's got to be on a pole, mounted on the pole. Don't attach it to the building. Don't attach it to the brick. It's got to be in the pole, and you can put it in the common area lava rock, which is like in our back 40 on the back of our units. We don't have a problem with that. But what happened, nobody really was enforcing all that. So during the course of all the years and previous boards and whatnot, since we're a condo association, even though we're townhouses, they weren't policing it. People have mounted these cockamamie things wherever they felt like it. So that being said, we've got 78 units in our association. I think it's like 23 buildings total. Just did a walkthrough again in the spring with our property manager and our other board member. We had these noted, okay, yeah, Mr. Jones has a satellite dish mounted on the brick. That's a no-no. This one's got it going through the aluminum siding. Oh my God, there's another no-no. Well, if they've already existed, there was nothing in the governing docs. We're in the process of changing our rules and regulations. So we want to incorporate all that into there. But here's where we're having a hard time figuring out is, do we grandfather in the people that already have them mounted in improperly? Or do we find them and say, okay, you caused damage to the brick and the vinyl. Now we've got to have this fixed. So it's on you to pay the expense. Does that make any sense, or did
It
I just?
There's a number of different layers to this. So
Yeah.
the first thing that I'm going to tell you is that satellite dishes are special.
Yeah, they are.
Satellite dishes are protected by the FCC over-the-air reception devices rule. That essentially means if you have language in your governing documents that says no satellite dishes, that is invalid because it is in violation of the FCC law that says owners can have a satellite dish up to 1 meter in diameter in any area over which they have exclusive use or control. For a condo association, that means that they have the ability to put up a satellite dish in their limited common area.
Right.
Where it becomes, so normally what you will see is you'll see people affixing the satellite dish. I will say because of streaming, satellite dishes are now kind of, they're on the downturn. We're not seeing as many as we used to. But you would see people attach their satellite dish to the side of their balcony, the railing of their balcony, in the bucket that's on the patio,
Right.
perhaps on the comm deck. But for a condo association, again, the rules are going to differ for townhome associations, but for a legal condo association, affixing the satellite dish into the side of the building or affixing it to the roof without association approval is generally going to be a no-no. So even though your governing documents probably don't talk about satellite dishes, it does talk about any additions or alterations to the common elements, and that requires owner approval. So I would talk with your legal counsel about what the best strategy is.
Okay.
Because the other thing that you're going to come up against is you very well may have satellite dishes that Eric installed and Eric left 10 years ago.
Right.
Carrie's in his unit and has absolutely no idea that Eric put up a satellite dish and that she basically purchased the unit with that satellite dish attached.
We have that happen a lot.
So the strategy might start with sending out a letter to everybody essentially saying, we're going to be reviewing the satellite dishes that are attached to the facade and to the roof, which are common areas and shouldn't have anything attached to them. If you have a satellite dish there, speak now or forever hold your peace. And then we can deal with the people that have stepped forward to say, yep, it's me, I did that. And we can, I would probably suggest grandfathering them in if that's still being actively used, conditional upon an agreement that they understand that they're going to be responsible for restoration once they're no longer using that satellite dish. You're going to pay the cost of it. And then if we know that we have 6 satellite dishes that nobody has claimed, I'd probably send the contractor out there and take them down. And I warn the owners, if you haven't responded to us to advise us that you have a satellite dish affixed to the building by this date, anybody that hasn't been claimed, they're all coming down.
And then do we send out if they haven't admitted to it and okay, we're going to take it down and you have.
It isn't claimed, take it down.
I'm sorry?
If no one has claimed it, I take it down. I tell them that that's what the plan is going to be. We're taking them down.
And send them the expense of doing so?
Well, we don't know who it is though. That's the problem. And so it might be waiting until we're doing something with the roof or doing something with the siding and then taking care of it at that point in time. So this is a very fact specific. Let's see what's going on, what's happening. Let's see if we can get people to raise their hands and claim these satellite dishes. And then let's figure out what the plan is going to be.
Where all of these are.
I'm sorry.
I'm sorry, didn't mean to interrupt you. Where all of the satellite dishes that are mounted, you know exactly who it is for that particular unit.
Okay.
I will say that because that's one thing I verified too. And I'm glad that you brought that up because I forgot to throw that little tidbit in. So we do know what unit it is specifically for.
Okay, then that's easy enough to just say.
But sorry, Dawn. I think the point is though too that if you don't know if it belonged to the current owner to charge them back for a prior owner who put that on there, that's where you might get into issues if you're charging back the cost of the removal and restoration. Terry, I think you're with Maisha, correct?
Yep.
I will talk to her on Friday when I'm in the Tinley office, and we'll get back to you on a plan of action with that.
Her and I've been working it out. It's no big deal, Carrie. I appreciate that. We actually have our board meeting tomorrow night. So
Okay.
I don't know if this will get brought up or not, but it's just while Dawn was here and I'm like, you know what? This has been gnawing at me.
Pick her
So,
brain.
I did. Yeah. I appreciate it.
Like dishes.
Absolutely. Before we end, I know there's two other homeowners on that had submitted pre questions. So I have a what's that?
I said I printed them for myself, but they're in super
look
tiny.
at that. I have a Renata on the call that asks, the webinar address electronic votes and reporting of results. If a community incorporates mail-in paper ballots and in-person voting, how would that affect the electronic vote process?
So if you're dealing with a condo and you have electronic voting, you're only going to have the electronic votes in the in-person ballots. There is nothing mailed in. I have to attend the meeting and hand you my ballot. So you're taking what is there from the printout from the electronic voting company, and then you're then adding the in-person ballots to the total calculation. If you're a Sika community, then yes, theoretically, you could also have the mail-in ballots, because that's more of the wild, wild west with voting, where you can have ballots, mail-in ballots, and electronic voting. You just can't have proxies if you have electronic voting. You would be doing the same sort of calculation. So making sure that I did not vote 3 times. We have Dawn Moody's ballot. She sent it in electronically on this date. If I then mailed in a ballot subsequently, the board would be counting the later dated vote. So if my mail-in ballot was after my electronic ballot, you throw out my electronic ballot, count the paper ballot. If I then showed up and said I want a ballot again, that's the ballot you're going to take. But it's making sure that we have a good record of who is voting, and then counting all of that stuff together.
If I can just add something on to that. Hello, thank you. And your presentation was very, very good. Very good. Thank you. Thank you all so much. What I'd like to add to that is the process in how things are counted. Is it, well, you actually answered it. It's all handled by either the company, even the mail-in ballots. Nothing is, okay, now the management company is going to take care of this. This is just, everything's handled with that electronic voting.
So
if it's a third party, them, or if it's the management company, their team.
So it's going to depend. A lot of times the board will have an electronic voting company that is only handling the electronic voting portion. And then your management team is handling the ballots that are cast in person and combining the results together. Sometimes what boards do is they utilize an accounting firm to handle the election process, both the electronic voting and the in-person ballots, and the accounting firm counts everything together and presents the results. If you're using management to do both the electronic portion and the other portion, they're the ones that are going to put things together. A lot of it's going to depend upon a case-by-case basis upon, the needs of a particular association. Certainly not with this management company, but I will tell you that I have a community with another management company where there is absolutely no trust of the management company counting ballots because of a situation that happened in the community several years ago. So they have outsourced the entire election process to an accounting firm, from basically soup to nuts. Initial mailings, call for candidates, everything else is coming from the accounting firm, because they want to make sure that there is no question about the integrity of the election. That is the rarity. And again, it was a very unfortunate situation, and it's probably been the only one like that that's ever happened to me in my career. And I've been doing this for 20 plus years. But if you have a contentious election and you know that you're going to have a contentious election, it is often helpful to make sure that you have, kind of an arm's length, either, somebody who's not your general day-to-day manager, a third party, the attorney kind of coming in and overseeing the election, so nobody can say this election is rigged. which always surprises me for a volunteer board position. Sometimes these elections in communities can get really contentious, just really, really contentious. And that's why if you know what's going to happen on the front end, as a board, as the community association manager, start planning ahead to say, what can we do so that nobody can question the integrity of the election?
I'd also just to end that with, even when you put some of these things in place, you know, best laid plans doesn't always go that way. However, we've experienced some issues with, we tried electronic voting, and I think it's the company. So it's a matter of vetting the correct company, I think, is the experience. But I just wanted to learn some facts on this whole thing and what is out there. And thank you. I appreciate it.
Thank you.
I have one more. So Carol, I have two more, sorry. Carol questioned the typical percentage of participation by homeowners. That's a tough one.
Carrie, you know this, the typical legal answer. It depends. It depends on the community. I can't really give you a good estimate. I will just tell you my experience has been participation is higher with electronic voting than with regular mail-in ballots or proxies. The easier you can make it for your owners to vote, to show up, to do something, the more turnout that you're going to get. So your annual meeting, an amendment to the declaration, if you can utilize electronic voting, you should do it because you're going to get more of a response from people.
Great. And then
So many of us are in front of our computers all day, every day. We have nothing better to do than to open up the association email, click and send in our ballot for the board election.
Okay, so then Paul had asked, and I'm not quite, I think some of this might have been answered, but I'm just going to read through it, and if we already touched on it, we could ignore that, but move on to the one that we didn't. So what is the legal requirements for voting via email? How much time before voting must homeowners be advised? That's part one of the question, so I'll let you touch on that.
Yep.
Hold on, I'm going to pull that up so I can read it again. So the notification for voting is 10 to 30 days if you are doing for your annual meeting. So that's the normal 10 to 30 days. Sorry. I can see this on my giant screen once I can get it to work for me.
Mm-hmm.
It's for the day. Having one of those moments. Carrie, can you read that part to me again?
Oh, I closed it out, Dawn. Hold on. Oh, the question? Sorry. What are the legal requirements for voting via email, and how much time before voting must homeowners be advised?
So again, for the owner's perspective, the legal requirements are you need to make sure that you have documentation by rule stating that this is what you are going to consider to be reliable and trustworthy. This is how we're going to handle electronic voting and electronic communication. It's gonna have to come from the email address, on file with the association. If it's not coming from the email address, if I'm voting on a particular matter, such as the association's has an amendment to the declaration, this is my ballot for XYZ association submitted on behalf of Dawn Moody. So basically putting requirements in place to say, this is how we can assure that the vote that's coming through via email on behalf of an owner, that it is legit on behalf of the owner in question. Again, as kind of noted previously, board members really should not be voting via email. It's right up there with, you shouldn't drive 60 in a 55-mile-an-hour zone because the law says, you have to drive 55. That's the posted speed limit. It's the same thing with boards where lawyers are going to have to tell you, you need to do your voting in person at an open meeting of the board of directors. There's a loophole. The loophole is associations do have the ability to conduct in my opinion, might not be the same opinion as other attorneys out there. You should certainly consult with your own attorney because that's the attorney's opinion who matters. But the Not-for-Profit Corporation Act does allow boards to take action outside of an open meeting based upon the unanimous consent of all of the board members. So if all board members say, yes, we want to hire this landscaping company, and they do it in writing outside of a meeting, everybody participates, then that is considered to be acceptable under the Not-for-Profit Corporation Act, and most associations are not-for-profit corporations. It is playing a little hard and fast with the rules, so it's not something that I ever recommend boards do as a matter of course, but it is kind of that, breaking case of an emergency remedy that's out there to say, okay, we've complied with the law. There's a law that supports this. But decisions really should be made at an open meeting, and to address meeting or decisions that need to be made outside of meetings, authority should be delegated to a board member or management to make those decisions that come up between meetings within certain parameters.
Okay.
Thank you. Thank you.
Part 2 of this, I think we touched on what issues can be voted on by emails, owners voting, and then we talked about board members and what. Yep, I think we've touched on all of the rest of Paul's questions.
Yeah.
Okay,
Yeah,
perfect.
thank you very much. Thank you, Terry. Thank you, Dawn. Thank you.
Was there any other questions from anybody here tonight? If not, that gets us through our Q&A portion. Oh, go ahead,
Okay.
Tan. Oh, you're muted.
Is that better? Can you hear me? Okay.
Yes. Thank you.
This has been great. I truly appreciate it. I just have a quick question in regards to when you mentioned about the governing documents. And I put something in the chat asking, like, if you are an association and you've been through, a lot of the governing documents are from the developers, and there may be some amendments or different property management changes. The way to get like the most updated your governing documents is to speak with your management company and have them work with your legal counsel. Is what I saw in the chat. And I guess my question to that is, would things such as like updated plats be in those documents as well, or is that something separate that you would need to also kind of?
So you're probably not going to have updated plats because the plats are normally the plats. You're normally not going to see things change too much after initial construction. Your governing documents that are recorded are going to be the ones that are going to be on file with management. If management isn't sure that they have all of the amendments out there, they can certainly work with legal counsel to make sure that you have a complete set of documents. If you have documents that are prior, to the 2000s, so if you have the documents that are dating back to the 60s, 70s, 80s, 90s, chances are your governing documents are probably out of date and do not necessarily reflect all of the changes that are set forth in the Condo Act or the Common Interest Community Association Act for non-condos. Both statutes allow boards to consolidate and update their governing documents. We call it amend and restate, to amend and restate their governing documents to bring the documents into compliance with the law. So basically take what's there, smush it into one document, and then make sure that it is consistent with what is set forth in the Condo Act or the Common Interest Community Association Act. That is a document that can be drafted and approved by the board alone. It does not require membership approval. Now, if you want to go change something substantive in there, we want to include a leasing restriction, we want to change responsibility for the balcony, something like that, that does require owner approval because you are changing something that's already there and you're not changing it to comply with the law. But you can update your documents as needed to bring it up to date with current law. Perfect. And if your documents are ancient, it might be something that you want to budget for next year to have done with your legal counsel.
Perfect. Thank you so much, Dawn. Thank you.
You're welcome. Okay. Well, thank you for all staying awake for this
Oh, thank you
really
very much.
entertaining topic.
Thank you, everyone. We really appreciate
Thank you.
everyone that was able to attend. I did do a poor job in not introducing Carrie Surratt earlier, by the way. So just for quick context, Carrie's our general manager in the Naperville and Tinley offices. The managers there report to our director, Marcia Nolan, and Carrie oversees Marcia and the managers in the offices out there. So she's currently CAI board president for Illinois as well. So she has a lot of great experience and authority on her end too. So apologies for that, but Carrie's an absolute rock star here at the organization, and really glad that she was able to be on and help facilitate things tonight too.
Thank you,
Thanks,
Carrie.
Eric.
Thank you very much. Thank you.
And thanks
Thank you,
to,
everybody.
again, for everyone that was able to attend. As I mentioned at the top of the call, we will be recirculating the recording along with the presentation so that you've got it for posterity. We'll also have it posted on the education section of our website. And then do look out for invites for our next round of webinars. We'll have a couple that are upcoming for July. That'll be exciting. And then we're going to be continuing these on a monthly basis. So if you're interested in attending or want to see those recordings, you'll always have those resources, whether on the website or just sending along to our board member list. So appreciate everyone making the time. If you've got any suggestions for future sessions that you'd like us to cover, always send them our way. And we look forward to seeing you guys at the next one.
Thank you.
Thank you very much. Thank you very much,
Thank you.
everybody. I
Thank
really
you,
appreciate it.
everyone.
Thank you.
Thank you so
Thanks,
much for
Dawn.
inviting
Thank you.
me.
Thank you.
Good
Thank
night,
you.
everyone.
Have a good night.
Have a
Good night. Good night.
Bye-bye.
Thank you.
Thank you.